As a victim of a crime, I filed my complaint. The court, after a trial, found the accused person guilty and sentenced him or her to imprisonment. After that, can I, as a complainant, file a lawsuit against the accused person and claim money as compensation, as damages from the accused person? This was a query recently posted to me by a client. And the client, after seeing a lot of Hollywood movies and also reading about a lot of these cases where after the conviction, after investigation by the police, after conviction by the court, the accused person goes to jail, but after that the victim still feels that there is some remedy which ought to be available. And on some occasions, the victim, especially that I've seen in the past couple of years, in couple of countries, the victim chooses not to file any criminal complaint, but instead chooses to file directly the civil lawsuit against the accused person. And is that possible in India? The answer is yes. Is it prudent in India? The answer is a very, very resounding yes. The reason why I would say that a victim of a crime should definitely file a lawsuit as well and not wait for a conviction is because, for example, and I've talked about it in another way about 6 months or a year ago in another video, where I give the example of this client against whom a criminal case was filed several years ago. And the client was wondering what is going to happen. And I explained to the client that the ingredients of the offense were definitely not being made out as he was accused of. But if the matter went to a civil trial, there could have been a lot of difficulty faced by this client. However, because it had been approximately 15 years since the filing of the complaint, since the date the dispute arose, now if the opposite party wanted to go and file a civil suit for possession, which was the grievance of the other party in this particular case, they would have been told by the court that their civil suit is now barred by limitation. And therefore, even here, if you are the victim of a crime, say for example, someone stabs you and runs away, and you complain to the police find him, there is perhaps impeccable, inescapable evidence, the person goes to jail for causing simple hurt. Apart from that, you can also file your civil suit for damages against that person, saying that this person stabbed me. Under tort law, he is liable to pay me damages that I claim to be fit to a decent extent, which the court also decides to be reasonable to a certain extent. But now if you wait for the trial to be over, and then after the trial is over, you wake up all of a sudden and realize that justice was not done, you will understand that the law only rewards those people who are diligent with their cases. And you will realize that if you did not file your civil suit for damages within 3 years of the date of the occurrence, one of the several articles, and I believe in this particular situation, the general clause, I don't think there is any specific clause in the schedule to the Limitation Act talking about what is the limitation period if you are stabbed by someone. But I believe because there is no such provision, the provision of Article 136 of the Limitation Act, of the schedule of the Limitation Act will apply, and you will have 3 years from the date of the incident before which you have to file your civil suit. And if you don't, the defendant, now in the civil suit, when they appear, the defendant / opposite party, when they appear, can file an application under Order 7 Rule 11 for rejection of plaint, and your plaint will be rejected. And even worse, in a situation like this, and I have talked it very recently, one of the components, one of the things that a judge will look at the very outset when you file your civil suit for whatever reason, apart from territorial jurisdiction, pecuniary jurisdiction, and what is the relief claimed, whether it is barred by some other statute. One of the main things that a judge will look at is whether your claim is barred by limitation, and the judge has the power to immediately dismiss your plaint only because period of limitation has lapsed. And if you cannot convince the judge that for A reason or B reason or C reason, I am still under the limitation period. Coming back to the original question, is it possible to file a lawsuit against the accused person who has committed an offense against you? The answer is a yes. Should you do it? The answer is most definitely a yes. Of course, you have to be careful about, many nuances of civil procedure, of what the courts have laid down to be necessary ingredients for awarding damages, including pleading as well as establishing the amount of damages, the loss of the actual losses that you need to prove, and many other things that you need to be careful of, considerate of, if you want to actually win that case for damages or for compensation.